Former President Trump has been kicked off another state's ballot. This time it's in Illinois. And the U.S. Supreme Court has agreed, meanwhile, to rule on whether Trump has immunity in Jack Smith's election interference case, an election year dispute that will have blockbuster legal and political implications for the entire nation. Shannon Bream is live for us in Washington, D.C. Shannon.
So, Harris, you know the Supreme Court does not enjoy being in the middle of election year political issues, but it's now juggling several cases that could have a big impact on this year's campaign. So I want to break down a couple for you. In addition to that Illinois judge who just booted the former president from the primary ballot, on Super Tuesday, you've got two other states that made the same decision, but it's all on hold pending a decision from these justices, the Supreme Court, about whether Colorado had the right to do what it did. The justices heard those arguments back on the 8th. That decision could come at any time. Both Colorado and Maine do have the former president's name on their primary ballots and say whether those votes will actually get counted or not is all up to that decision we are awaiting from the justices. Could come at any time. Well, in many respects, the legal team for Trump could also argue that they got a win from the Supreme Court yesterday simply by virtue of the justices deciding to take up the case about whether he has some sort of immunity in the Jack Smith January 6th case against him. This is the exact question. You got a lot of lawyers there on the couch with you. This is what they've agreed to hear in April. Whether, and if so, to what extent, does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? Yesterday's order from the court does not tell us how each of the justices voted, but they made clear the court is not, quote, expressing a view on the merits yet. Decision due by late June. Only then would the trial court lift the pause on proceedings, which could then take weeks or months to actually get this thing to trial, meaning it could end up in summer, early fall, even later, Harris.
Wow. All right. So you've given me some homework assignments with our legal eagles here on the couch. Appreciate it always, Shannon. Good to see you. All right. So let's just unpack that a little bit. First of all, what happens in those states like Illinois and others? And we can pop up a map. There are others who would love to join the party, but either they've been dismissed in those states, and those will be in blue, or they were dismissed on appeal. The rest of states might be interested in trying to take him off the ballot, like Maine and Colorado. So what happens?
The Supreme Court is going to have to weigh in here. And in hearing arguments on the states so far, what we saw is that this isn't just a 6-3 divide in the Supreme Court. This could be a 7-2 decision, an 8-1, or maybe even a 9-0 decision. There seems to be bigger support than just that 6-3 breakdown to prevent this. I don't want to hear anything from the left about attacks on democracy when you see an attack like this. There is no greater threat against democracy than Joe Biden and Democrats saying that Americans don't have a right to choose their own president in November. This is the greatest threat to democracy that is imaginable.
Well, it's also like a really big deal about election interference. Why doesn't anybody ever call it that? I call it that.
That's right. It's perfect segue. You must have been reading my mind. I spoke to someone the other day, a loyal Fox watcher, and someone who said, look, my biggest concern...
Recently, you had the chance to view a clip from Fox News, and we trust you found it engaging. We're eager to share our insights and kickstart a discussion, so feel free to dive into the comments section. If you appreciated the video, don't forget to like it, follow, and subscribe to our channel to stay updated with more content of this kind. The latest move by the courts to disallow President Trump on the primary ballot in a third state is not only disturbing, it's a flagrant assault on the democratic process. Imagine for a moment, 3 states now stand accused of direct interference in an election by attempting to silence the voice of a major candidate, and not just any candidate, but a former president beloved by millions. This situation teeters on the brink of judicial overreach and, worst, election manipulation, raising questions about the impartiality of state courts. Furthermore, the Supreme Court's decision to consider whether Trump has immunity concerning the Jack Smith case is a beacon of hope, signaling that at least at the federal level, the judiciary remains a bulwark against potentially partisan decisions at the state level. The implications of this case could indeed be monumental, not just for Trump, but for the presidency and legal standards moving forward. If the Supreme Court rules in favor of Trump's immunity, it reaffirms the protection of the office's sanctity. Conversely, To rule against it would set a precedent that could open a Pandora's box of legal woes for any former president, regardless of party affiliation. The undeniable politicization of our judicial systems must be addressed. If states can remove a leading candidate from the ballot without just cause, the very fabric of our electoral process is under threat. Such an action reeks not of justice, but of a tactical maneuver to stifle political opposition. As conservatives, as Republicans, and indeed as Americans, the importance of fair play in our democratic system is sacrosanct. The courts, both state and federal, must uphold this principle. Whether or not President Trump's name is on the ballot should be a decision left to the people, not the result of questionable legal interpretations and potentially partisan judicial activism.